Thank you so much, and I would like to start by thanking you, Rosario, and Luciano for having invited me here. I've been enjoying this workshop so much. I really like the mix of different angles, and I hope that since my presentation is based on law, it will not be too boring, because when I saw the title of the workshop, Understanding Responsibilities of Online Service Providers, I interpreted this as legal responsibilities, and that's where I built from, given my own expertise. So perhaps you don't immediately see the link between the Roman law, and the internet, but we shouldn't forget that Roman law actually served as a basis for legal practice throughout Western continental Europe. My title refers to a number of what we can consider online service providers. Now, what do they have in common? They can all be considered information society service providers in the sense of the e-commerce, which is a very broad definition, basically covering every type of provider offering every type of service via a distance, via electronic means, be it the internet or more traditional networks. And they all went through long court procedures invoking one of the safe harbor provisions that have been harmonized in Europe under the ECommerce Directive. Now, just let me check who is already familiar with these provisions. Articles 12, 13, 14, most of you are. So the mere conduit, caching, hosting provision shields these or providers offering these type of services from criminal civil liability under certain circumstances. And the ECommerce Directive, as was already mentioned, also puts forward a prohibition on states to require from information society service providers to monitor systematically the content, the information streams that goes via their services, networks, platforms. So no general obligation to monitor, as was confirmed by the Court of Justice in the Scarlett versus Sabam and Sabam versus Netlock cases, two cases where collecting society, Sabam, representing the interests of rights owners, tried to obtain from Scarlett on the one hand, Netlock on the other hand, to filter materials that would pass through their platforms. But the Court of Justice of the EU interpreted the relevant directives, in that case the Directive on Copyright in the Information Society, the Copyright Enforcement Directive, the Data Protection Directive, the E-Privacy Directive and the E-Commerce Directive, together with the fundamental rights in Europe. According to the court, these had to be interpreted as precluding an injunction made against an ISP which requires it to install a system for filtering copyright infringing content when this would have a general application. So if it would apply to all communications passing via its services, if it would apply indiscriminately to all its customers, when it would be implemented as a preventive measure, when it would come exclusively at the expense of the ISP, and if it would apply for an unlimited period. So that type of monitoring obligations would go against EU law, the court said. Now, the same principles as we find in EU law are also reflected in this declaration that is adopted by the Committee of Ministers of the Council of Europe in 2003, the Declaration on Freedom of Communication on the Internet. Member states should not impose a general obligation to monitor content. They have to ensure that they are not liable for content when their function is limited to transmitting information or providing access to the internet. But probably the provision that causes most interpretation problems is this one. In cases where the functions of service providers are wider and they store content emanating from other parties, member states may hold them co-responsible if they do not act expeditiously to remove or disable access to information or services as soon as they become aware of their illegal nature, or in the event of a claim for damages of facts or circumstances revealing the illegality of the activity or information. Now, what is as soon as they become aware? Does it imply that they have to act upon receiving notification by a victim, or does it also imply a kind of active duty to react when, on the basis of reading something in the newspaper, for instance, that they might think that something is wrong with content stored on their servers or passing through their platforms? And does it mean actual, or does it mean constructive knowledge? You refer to Simon, you refer to actual knowledge, but in some cases constructive knowledge is required. I'll come to that. This discussion about what kind of, or what does it mean to become aware, was also a core element in the discussion surrounding a legal conflict that arose in Estonia in relation to Delfi. And this was a case about ice roads. Now, you might think that this is not particularly important, but it is. At least in Estonia, ice roads are crucial. So let's take a closer look here.
The frozen surface of the Baltic Sea. It might be too slippery a ride for the more nervous motorist, but for people living on the islands off Estonia's coast, ice roads like this are a lifeline. There are many ways to get from A to B in these parts. On four wheels especially, travellers should be aware of the risks. Hence this good advice from one of those in charge of ensuring ice road conditions are safe. The key rule is that your speed should be either between 10 and 20 kilometers per hour or 40 and 70 kilometers per hour, not in between, says the roadmaster. Otherwise, there'll be vibrations that can break the ice. Fluctuations in the water levels of the Baltic Sea can create cracks in the ice roads. Wooden tracks are used to bridge the gap. Depending on the weather, Estonia's ice roads can stay open until the middle of March.
Great place.
Well, I hope that after lunch this got back your attention. And you undoubtedly have learned something you didn't know, even if my presentation it might be too boring for you. So ice roads are a lifeline in Estonia to connect mainland with islands. And the Delfi case, a ruling of the Court of Human Rights, so not the Court of Justice of the EU, but the European Court of Human Rights, was the first case that actually dealt with liability for user-generated comments on an internet news portal, because Delfi was one of the largest news portals in Estonia, publishing news itself, articles of its own journalists, in Estonian, in Russian. It also operates in Latvia and Lithuania, and it allowed its users, its readers, to comment on the articles it put online. So it user-generated content. It offered a platform for user-generated content. And it had put on its website a disclaimer on liability for user-generated content. It had put in place a notice and takedown system. In its policies on UGC, it had mentioned that it would not allow hate speech or no insulting comments, and it would filter out obscenities. But when Delfi published an article on how a shipping company, SLK, had destroyed a planned ice road, this triggered a lot of offensive comments, about 185 in a short period of time, of which 20 were subject of the court proceedings. And Mr. L asked Delfi to remove those comments, and they were comments like, let's do as in 1905, let's go to Kuressaare with sticks and put Mr. L in a bag. Mr. L was the main shareholder and also board member of this shipping company. Bloody shitheads, burn in your own ship, sick Jew, go and drown yourself, rascal, let's fucking monkey, I will cross the strait anyway, and if I drown, it's your fault. So that type of comments were involved. Excuse me?
No, you're just referring to the philosophy department, so it just is this philosophy undergrad.
Yeah. Okay.
That's the debate. No.
All right. So the commons stayed online for about 6 weeks. At Delfi, despite its measures that it had put in place, didn't notice or didn't want to notice the commons. Let's leave that aside. And at some point was contacted by Mr. L's lawyer, who notified Delfi about these commons. Then Delfi removed them, but refused to pay damages for the sorrow, the grief that was done to Mr. L, the damage to his reputation. Now, the national courts held Delfi liable for these third-party commons. Delfi invoked immunity defense, an immunity defense argument on the basis of the ECommerce Directive, well, the national transposition of it. But the national courts rejected this and found that Delfi had editorial control over the commons section and hence should have prevented clearly unlawful commons from being published. Delfi brought its case before the European Court of Human Rights, who in 2013, the first section of the European Court, in a unanimous judgment, came to the conclusion that there was no violation of Delfi's free speech rights as protected under Article 10 of our European Convention, because Delfi could have realized that the article might cause negative reactions against the shipping company and its managers, and that there was a higher than average risk that the negative comments could go beyond boundaries of acceptable criticism and reach the level of gratuitous insult or hate speech. It was in a position to know, it had put this article online itself, so it was in a position to know about this article when it would be published, what the reaction might be, and so it was also had technical control. Technically speaking, it could imply measures to prevent defamatory statements from being made public, and moreover, the €320 fine that Delfi had to pay according to the national court was not disproportionate given the fact it was a large media, professional media organization. Now, this ruling caused a storm of controversy. Several scholars called it a deeply worrying precedent for freedom of expression, a serious blow to freedom of expression online, and a profound failure to understand EU legal framework. Read the ECommerce Directive that includes shields, or that shields certain intermediaries from liability. And it conveniently ignores here, this blog on Inform says, it conveniently ignores relevant international standards in the area of freedom of expression on the internet. It's a decision that cries out to be overturned on appeal by the Grand Chamber, and effectively the Grand Chamber accepted the case. And in 2015 it came to its conclusion, so just a few months ago, and actually it confirmed the ruling of the first section. This was a 15-2 decision, so not a unanimous decision. There were 2 judges who actually disapproved, but still, 15 out of the 17 judges supported the conclusion that there was no violation of Article 10. Now, this ruling clarifies, amends, corrects the first ruling. Well, for us lawyers, it's a bit like poetry, but I understand that if you don't have a legal background, you probably not read the text. It's a long text in detail. So let me give you some highlights of the text. The court starts, because many people said the court doesn't understand the internet. Well, the court thinks it does understand. It says, we believe the internet yields a lot of benefits. User-generated expressive activity on the internet provides an unprecedented platform for the exercise of freedom of expression. But alongside these benefits, there are certain dangers that may arise. There's the stickiness of the internet. You put something online, it stays there for a long time. It's publicly on a global scale. And so these 2 conflicting realities lie at the heart of this case, the court starts with. It also carefully delineates its conclusions by saying, we are talking in our ruling about professional media organizations, internet news portals that provide for economic purposes a platform for UGC. And secondly, another very important delineation is we're talking about hate speech comments, so comments that cannot benefit from the freedom of expression protection under Article 10. So those are 2 important nuances that you should always keep in mind when you assess the conclusion of the ruling. Now, as is usually done in Article 10 rulings, the Grand Chamber follows the so-called three-step test. Was the infringement prescribed by law? According to the court, it was. A large professional media organization could consult lawyers in order to know if there was a risk that it would be held responsible. Was it the infringement, the aim of the infringement, was it legitimate? Yes, the court says it's to protect the rights of others, reputation rights, privacy rights. Was this infringement necessary in a democratic society? And here the court confirms the 4 criteria that the first section had put forward. And so with regard to the context of the commons, the court considered that we were talking about a media organization that had a certain reputation. It was notorious for being a source of very insulting comments. This was addressed in an open letter by another newsletter. So Delfi was known in Estonia for providing such a platform. So the European Court agrees with national courts that the role of Delfi went beyond that of a passive, purely technical service provider. With regard to the liability of the authors of the commons, the court, well, first it recognizes that anonymity on the internet may be beneficial in certain circumstances, but it also, now I have to see that I phrase it carefully, it also says that the court does not lose sight of the ease, the scope and speed of the dissemination of information on the internet and the persistence of information once disclosed, and that anonymity, although it is an important value, must be balanced against other rights and interests. So the fact that Delfi allowed its users to post comments anonymously deprived the victim from a real possibility to go to the actual authors. So Delfi was basically the only one they could turn to. So that was an important element in the court's ruling as well. Thirdly, what were the measures taken by Delfi? Well, here the court says Delfi did not completely neglect its duty of care, but its systems had not worked. They did not filter out comments which were clearly hate speech, which were, and the court says, like on their face, without linguistic or without legal analysis, they were clearly unlawful. And the court also says, well, the fact that we require from Delfi certain measures, or the fact that they react against such comments, can by no means be equated to private censorship. And then finally, the consequences for Delfi, what were they? Well, a moderate fine, according to the court. So that was not a disproportionate infringement. And also the fact that after the Delfi, the national court cases, after the Delfi ruling, national courts in Estonia had taken similar decisions, but they had never imposed huge fines. So their rulings were limited to, let's take these comments down. So here again, the court said, well, the effect for Delfi in similar, comparable intermediaries is not disproportionate. So that explains the court's ruling. As I said, not everybody agreed. 2 judges heavily criticized in a joint dissenting opinion the ruling, saying it establishes a form of collateral censorship, and the fact that the court approved the liability system that imposes the requirement of constructive knowledge on active internet intermediaries means collateral censorship. Now, this constructive knowledge refers or brings back to mind the ECommerce Directive system put in place in the EU. So several scholars asked, what if the European Court had applied the safe harbor provisions? The European Court doesn't refer to the ECommerce Directive. So we can, by way of theoretical test, what would have happened if the European Court had applied the safe harbor, or, like in the SATA Media case, would have asked the European Court of Justice of the EU for advice on this. let's take a look at what we can learn from the Court of Justice of the EU case law with regard to intermediaries. In the Google France case, okay, I'll go very quickly, because here again I assume that most people have heard about these cases. In the Google France case of 2010, which was in the area of trademarks, the court put forward the neutrality requirement. Did the intermediary act as a neutral, merely technical, automatic, passive intermediary? If it fulfills such a role, it cannot be held liable for data stored, and the mere fact that a referencing service is subject to payment, that the provider sets payment services, or that it provides general information to its clients cannot have the effect of losing the protection. Now, in the case of eBay, that came out a year later, L'Oréal versus eBay, the court changed from the neutrality requirement to the diligent economic operator criterion. And it stated that an operator cannot rely on the exemption from liability if it is aware of facts or circumstances on the basis of which a diligent economic operator should have realized that something was wrong, that in this case offer for sale in question had been unlawful. So the diligent economic operator criterion. Now it left open the question to what extent the diligent economic operator can actually be expected to carry out investigations on its own initiative. In that regard, we need to think back about the Netlog and Scarlett cases, where the court clearly stated that a general monitoring obligation cannot be imposed on ISPs, but, and this is where UPC TeleKabel in Vienna comes in this case the court confirmed that outcome prohibitions, injunctions ordering ISPs to block users' access to a website infringing copyright, but without specifying how that result has to be achieved, are compatible with EU law, including fundamental rights. According to the court, this was not an unreasonable measure, okay, given the fact that the ISP had certain freedom on the measures to impose, and so it could avoid liability when taking all reasonable measures. Now, what are these reasonable measures? Measures that shouldn't be excessive, the court says. They should not unnecessarily deprive internet users of the possibility of lawfully accessing information available. They have to be strictly targeted, and they should be sufficiently effective, even though that doesn't imply 100% effectiveness. Now, that still does not learn us what is a reasonable measure in the case of online news portals. In that regard, we can also make reference to the Papa Savas case of the Court of Justice, which came out on 9/11 of last year, where the court found that a newspaper publishing company cannot enjoy the liability exemption because it knows what information it publishes online. This was not a case about liability for third-party comments like in Delfi, but it was about liability for its own content. Now, if we look at these terms, and I'm coming to the end, diligent economic operator, reasonable measures, there is a concept that goes back to Roman law that might come to your mind. No.
Slavery.
No. No idea? Bonus pater familias. Yes, indeed. The good father. Excellent. Which is a basic concept.
No, it's in Spain we study Roman law.
Yes, indeed. So it's the first thing you learn. In Belgium and France, it's Article 13, AD 2 of the Civil Code. So it means that you should act as a prudent person when you deal with your fellow human beings. And it has been used by Belgian courts to determine liability of media organizations in the sense that the courts looked, and this is where we come to the ethics, courts in Belgium looked at the ethical code of journalism in order to establish whether a particular journal or newspaper outlet acted as a normally a reasonable and prudent actor in society. So what does this code say? And this is where I'm going to close the circle. This code says, on discussion forums, opinion contributions are firstly the responsibility of the author of this contribution, but the medium publishing the contributions is professionally and ethically responsible for proper moderation of the forum, which can be done either through pre-monitoring systems, by active moderation, or by post-monitoring. And here it says the following methods can be implemented for the timely removal of inappropriate content, moderation prior to publication, and continuous discussion guidance when concerning sensitive topics like ice roads. So what is this main storyline? That a very basic principle that underpins our law systems, at least in continental Europe, but common law has the reasonable man concept, is like a consistent guidance for courts that deal, in my view, that deal with intermediary liability. When they talk about reasonable measures, when they talk about a diligent economic operator, it's like they talk about a bonus pater familias. So how do you know then what a bonus pater familias should look like when they are an online news portal or, in this case, a media, newspapers? Well, we can look at their own standards that they themselves put forward. And here they themselves say, if you publish something on a sensitive topic, you may have to continuously guide the discussion. So this is where the ethics come in. So courts should also look at ethics. So I hope that in this way, by combining law, ethics, perhaps also economics, to know about what the economic costs would be of certain measures, we can determine better what the duty of care should be for intermediaries. Thank you. And I took too long. I'm sorry for that.